We are back with another video update, and today we will be briefly talking about the changes in Start-up and Innovator visa categories that will take effect on the 4th of June 2020, and the alterations to the European Union Settlement Scheme that will come into force on the 24th of August 2020. Before we continue, please support us by subscribing to our channel and press the bell icon to get latest updates on United Kingdom visa and immigration, especially during the COVID-19 pandemic, as we have a dedicated playlist just for you. So without any further delays, let's start the video. New Statement of Changes to the Immigration Rules. May 2020 Update. New Statement of Changes to the Immigration Rules commands modification to European Union Settlement Scheme and Start-up and Innovator visa categories. Modification in the statements of changes include expanding the extent of the domestic violence provisions in European Union Settlement Scheme. The latest Statement of Changes to the Immigration Rules, CP 232, has been published on 14th of May 2020. You can read it and the associated explanatory memorandum on the official government website, gov.uk. The exact link for the main 27-page Statement of Changes is mentioned in comments section below. The descriptive memorandum mentions the modifications will make revisions to the Start-up and Innovator categories, apply a few small alterations and modifications to the rules, make changes to the European Union Settlement Scheme. The modifications will take effect on the 4th of June 2020, while the alterations to the European Union Settlement Scheme come into force on the 24th of August 2020. The modifications in the European Union Settlement Scheme comprise outspreading the extent of the domestic violence provisions. The explanatory memorandum remarks, in line with the Withdrawal Agreement and the Free Movement Directive, this is at present restricted to a former spouse or civil partner whose marriage or civil partnership has been lawfully ended and who was a victim of domestic violence or abuse while the marriage or civil partnership was subsisting. Consistent with the government's wider pledge to confronting domestic violence or abuse and protecting victims of it, the changes will mean that any family member within the scope of the EUSS, a spouse, civil partner, durable partner, child, dependent parent or dependent relative, whose family relationship with a relevant European Economic Area citizen or with a qualifying British citizen has broken down permanently as a result of domestic violence or abuse, will have a continued right of residence, where this is warranted by domestic violence or abuse against them or another family member. They will be able to rely on this, together with their own continuous residence in the UK, in applying for status under the EUSS. The modification also bring family members of the nationals of Northern Ireland within the range of the European Union Settlement Scheme, with the explanatory memorandum clarifying. This will denote that qualified family members of the people of Northern Ireland will be able to apply for UK immigration status under the EUSS on the same terms as the family members of Irish citizens in the UK. This immigration status will be available to the family members of all the people of Northern Ireland, no matter whether the person of Northern Ireland holds British or Irish citizenship, or both, and no matter how they identify. The Start-up and Innovator categories will also have a number of modifications. The explanatory memorandum states, modifications are being made to make it clearer that, to be endorsed, applicants must be founders of their businesses and be relying on their own business plans. These changes also clarify that an innovator applicant's business may be already trading, providing they were one of its founders. An obligation is being added for decision makers to request further information or evidence from applicants or their endorsing bodies if they have concerns that an endorsement has been issued inappropriately, and to refuse applications if they are not satisfied the endorsement criteria have been met. The viability criteria are being amended to also require that a business plan must be realistic and achievable based on the applicant's available resources. The rule around applicants who wish to change their business venture, previously only set out in guidance for endorsing bodies, is being added to the immigration rules. This sets out that applicants may change business venture, providing their endorsing body is satisfied. The new venture meets all of the criteria for endorsement. The applicant does not need to obtain a fresh endorsement or make a fresh application. Our video ends here today. Please subscribe to our channel now to get similar updates on UK visa and immigration.